listening to Driving Law, a podcast by Kyla about all things related to the rules of the road.
Hello, and welcome to another episode of Driving Law. I am Kyla at Acumen Law, and with me, my co-host, who thought it was recording and it wasn't, Paul Doroshenko.
That's why Kyla was laughing. She doesn't have confidence over my skills with respect to the audio portion of the podcast, which I guess is the important
Video.
part of it. Oh, yeah, I think you could see there's a countdown. The video is going.
It is now.
That's true. It wasn't when I thought it was before. So here we are.
Here we are.
Friday. Happy Friday.
Yep. Happy Friday, and it's the last days of February. In March, the 30-kilometer-an-hour residential streets start going up in Vancouver.
That and it's Distracted Driving Enforcement Month. The BC Association of Chiefs of Police have their annual schedule of calendar of enforcement. So next week you can expect on Monday that they will be out enforcing cell phone tickets and out there with the media, so they can try and get it on every newscast for the public education aspect of it.
Yeah.
So 30 kilometers an hour.
Yep.
Going to be signed, though. It's going to be putting up signs for it.
Speed against municipal sign will be the offense.
And it's going to be on pretty much every street in Vancouver that doesn't have a line on it.
Yeah, although I don't think they're going to be putting up all the signs right away.
No.
It's a slow rollout.
Yeah. That's fine. I drive 30 on those side streets.
Do you know what else the city of Vancouver announced yesterday?
What?
That they're taking the old Woodwards building downtown that the London Drugs used to be in, but they moved out because crime. And they are putting in their own Vancouver Police Training Academy with a view to doing all training for VPD officers in-house and no longer using the Justice Institute.
I had no idea. This is totally news to me. Yeah. I didn't know that.
Yeah.
If you're listening from outside of BC or you don't know, we have something called the Justice Institute, which is a school, and New Westminster is the location, and it trains police officers from all over BC for all of the different municipal police forces. And it's been like the contract trainer, well-regarded training for police officers in British Columbia. So the VPD, I guess, wants to train their officers differently. That concerns me.
Right?
Yeah, because we've seen some very bad things from VPD lately.
Well, VPD, historically, I have to say, as somebody who reviews a lot of different police detachments and departments and their practices, VPD has the worst note-taking practices of any police force.
Yes.
They don't seem to think that taking notes is important at all, when it is, in fact, the courts have repeatedly said. Very important.
Well, what I've noticed is that you've got very senior officers who are very skilled and very knowledgeable, and they retire, and none of the information from those officers seems to be passed on. So there's like all of that value, all of that lived experience, learned experience is not passed on to the junior officers. The junior officers are basically just out there. They have so many different duties that they never gain the expertise they need in traffic enforcement, which is where the rubber meets the road as far as we're concerned. And so this seems to be the ongoing problem. And it's the reason that we catch police officers from Vancouver so often in providing information that is just, we can prove false on the basis of video or some other reason.
I think we talked about it before. We had a case recently where the body cam
completely contradicted everything that was asserted by the police.
Everything. Yes. Yeah. So yeah, I mean, I don't like the sort of insular in-house training of only one department training itself, because then you have only one perspective. Whereas with the Justice Institute, you've got the perspectives of different officers that are in your class that you're learning with and from at the same time.
And some of them are already been trained in other places.
Some of them might be RCMP officers, etc.
Come from the UK.
And you also have different trainers from different backgrounds and places that are being brought in, rather than, what I assume will be just officers training officers. Blind leading the blind, as they
Well,
say.
maybe though, they're going to get those senior officers that I was just speaking of a moment ago. Maybe they're going to get those people to come in who are retired, and maybe they're going to be able to pass on some of that institutional knowledge. But right now, officers who are under the age of 40 um, in Vancouver, I will say, just generally categorizing them, I am concerned. I am concerned. So maybe, I don't know, we'll just hope that they've contemplated some of these concerns, and as they listen to our podcast, they will think about how they can meet the requirements of Kyla Lee and Paul Doroshenko.
They could invite us in as trainers. They could pay us to come train police on how to withstand cross-examination or how to conduct an impaired driving investigation. In fact, really, they should.
You do this without being paid.
Yeah, I know, but they're creating their own academy, and I pay taxes in Vancouver, so they can pay me.
All right.
I guess I pay taxes other places too, though.
Yes, you pay taxes in other jurisdictions in the province where you happen to own property.
Yeah. Anyway, the completely switching topics entirely.
Yeah.
Earlier this week, I went to the retirement of a judicial justice from traffic court.
The first judicial justice I ever appeared in front of when I was an articled suit.
Yep, me too.
Yeah.
Yeah. I had this one particular client that stands out in my memory who ran a red light, and I had to deal with his case in front of that judicial justice.
Yes.
Anyway,
Good client, though. Nice guy.
the
Allegedly ran a red light.
found not guilty.
Exactly.
Where was I going with this? I don't know. It led
Retirement of the judicial justice.
It had a transition into traffic court. Oh, right. At the retirement, a lot of people were talking about sort of how traffic court became traffic court. And how originally when the sort of traffic court process was set up, the people who decided your traffic ticket cases were not independent, members of the judiciary, but they were instead, these like traffic court referees
Yeah.
who would adjudicate it, but they were civil servants, which, raised problems about the independence. And the judicial justice who retired was the person who led the charge to have them become recognized as judicial officers instead.
It changed a lot.
Yeah.
So when I started practicing, when I first went to traffic court, this was the early days of this, right? After they were no longer just government employees and referees, as they referred to them, and they created this judicial branch, called them justices of the peace, I guess, at the time. But there was no lawyers. There was never a lawyer there. It was either myself or Kevin Filko. We would be the only two people who would run into each other there. And all the lawyers, whenever you would see a lawyer there, they'd be like, I'm embarrassed to be here in traffic court. And I always thought, why are you embarrassed to be in traffic court when, you're getting paid legal aid rates for very little money to defend people who break into cars at Science World? Like, they're clients who need help one way or another. Why are you embarrassed? But I didn't think that at first. I was just embarrassed in traffic court as well, because I thought, is that what I'm supposed to be? Embarrassed in traffic court? But Kevin Filko and I would run into each other, and that would be the only person I would regularly see down there. And now there's a bunch of lawyers going down there, but that was half the lawyers who are there are formerly worked with us or work with us.
Well, that brings me to traffic court. And specifically
we were talking about traffic court.
appeal. Yes,
Sorry.
a traffic court appeal. Specifically a traffic court appeal about an electronic device ticket where there was an allegation that the judicial justice caused an unfair trial.
Yes. So go into this one. I did read it.
So this is an individual who was alleged to have been using an electronic device while driving. The police officer was wearing body cam. Vancouver police wearing body cam. He walks up to the window, and there's some glares on the window. You can't actually see, apparently, in the video that he's using his phone, but you can see the back and forth between the officer and the driver. And at trial, he testified, and the officer didn't play the body cam footage in his testimony because it didn't show the offense. but the accused asked for it to be played during his evidence and pointed out the glares on the window that would have obstructed the officer's view. He said that he was like using his what was it, like his taxi thing, taxi radio thing. I don't know what it was, some taxi equipment.
Yeah, the radios the taxis have
Yeah.
to deal with their
Yeah.
dispatch.
Yeah, and that was what the officer mistook as him using his cell phone. And in his cross-examination, the officer challenged him on a number of things that the accused had said in the course of his testimony, and he asked for the video to be replayed to respond to the questions, and the judicial justice said, "No, I'm not going to permit you to replay the video."
If you're putting it to him in questions, obviously you can replay the video for the purpose of that. If you're showing him something, I haven't seen this case. Then this is not the case that you. I guess I
No.
read a different one earlier this week.
I didn't send this one to you, so I
Anyway.
was surprised you'd read it.
No, that was on Matt Smith earlier this week speaking about the cell phone enforcement. Anyway, go ahead.
So yeah, there's the court had to consider whether a miscarriage of justice arose from the failure to play the video during the appellant's cross-examination. And the court found that it was not, that it's, the purpose of cross-examination is to permit the cross-examining party to test the evidence of the other person and to explore the frailties of their testimony. A witness answers the questions posed and is not supposed to divert the questioning by asking to have an exhibit such as a video played again.
But if somebody contradicts something that's on the video, says something that's different from the video, you've got to be entitled to impeach them by showing the video.
No, you're confused.
Okay.
Constable Kim
Yes.
was cross-examining the accused.
Yes.
The accused was the one who played the video during his direct.
Yes.
Constable Kim asked him questions, and the accused wanted, during cross-examination, to play the video again.
I thought it was Constable Kim wanted to play the video again. The accused wanted to play it
The
again.
accused wanted to play again, yeah. The questioner, of course, could play the video again. If Constable Kim had wanted to put a portion of the video to them, he 1,000% would have been permitted to do so.
Thank you for clarifying for me and the audience.
Yeah, sorry I wasn't clear.
Yes.
I'm sick. My brain's working at, 50% capacity.
Very happy to be sitting so close to you while you're sick. This is
I'm
one
not-
of those days when I would prefer that we did it from a distance. From a distance. I'm sorry. Keep going.
Wow. I don't think I'm contagious anymore. It's been enough time.
Hope not.
I don't have a fever anymore. Anyway, so the point is, it's the right of the cross-examiner to decide how to pose questions and what exhibits should be used during cross-examination, subject, of course, to trial fairness issues. And there wasn't a trial fairness issue because he wasn't prevented from responding to the question. He was prevented from diverting the questioning and going back to his points about the video that he'd made in direct.
Yeah.
Which, fair enough.
And it sounds like it's just an attempt by the person under cross-examination to try and recast the evidence that's already there in front of it, which is it's already been played and something you can just refer to.
Yep. Anyway, I liked that commentary about the point of cross-examination and the power that the cross-examiner has. But I also like that, here's an example after, I had a little reflection this week on fairness and independence in traffic court of a judicial justice being accused of being unfair, but having been found to have been nothing but fair.
Most of them are. Most of the time. They're doing their best, so that's just how I see it.
Fair.
Sometimes I think people are shut down a little abruptly, and sometimes I think that it could have gone differently, but for the most part, I think, justice is served in traffic court.
So here's the other case. This is the case I think you knew we were going to talk about, the Martel case out of Alberta.
Yes.
So this is a case from the Alberta Court of Justice, or was once known as the Alberta Provincial Court, where Mr. Martel was accused of fleeing the police, basically, failing to stop for a police officer who was pursuing him while he was
on a motorcycle.
A motorcycle. Very interesting case because he testified that he didn't know that the officer was behind him because he'd modified his motorcycle that it was so loud he couldn't hear the sound of the police sirens. And so therefore, he couldn't have committed the offense because he didn't have the mens rea.
The problem was he was disbelieved on so much that his credibility was so impugned that I don't think that was something that was going to have won the day, even if it had been. I mean, the way the court interpreted it was like basically you're willfully blind and you've set yourself up to be willfully blind. It mentions that, but I think it ultimately what it hinges on is a lack of believability in his own evidence. But the interesting thing is he gets away from the police. He goes into a hotel or like a walk-in motel where you can sort of see the door. Other police officers arrive. That main police officer doesn't maintain continuity. Somebody comes out and he's detained. And there's some statements he makes that could indicate that he was the guy, but he also testifies that there was another person that he never really identifies properly. But there's a very important thing for motorcycle season coming out of this case, but feel free to continue with where you're going. I just wanted to make sure the facts were clear.
Well, since you brought it up, I just wanted to read some passages about the credibility analysis because I thought they were kind of funny.
Yeah.
In the absence of any supporting context, the bare statement by Mr. Martel regarding an unverifiable potential bike purchaser, in my opinion, is a bald assertion that effectively constitutes a bald denial of his identity as the culprit riding the bike on August 26, 2024. I will subsequently examine this bald denial or assertion in the context of the totality of the evidence. Notably, also, Mr. Martel alternated between describing this unverifiable individual as a friend, a buyer, or simply a person. This shifting descriptions obviously undermine the reliability of his evidence as well as its credibility. In sum, Mr. Martel's explanation that an unverifiable third-party potential buyer of his motorcycle could have been test driving his motorcycle at the precise moment of the police pursuit is unsupported by the globality of evidence before me in this case.
I mean, come on. If somebody was driving your bike 5 minutes earlier, you would remember that. When you were arrested, you'd be sitting there. It would be crystallizing in your brain and you'd be able to come to court and testify unless you're just making it up after the fact.
Like, you don't have to assert it at the roadside, obviously.
No.
But, you might have, I don't know, a text message thread with this person. Like, when could I come test the bike out? Emails, Facebook messages.
Yeah.
Like that. There had to be some sort of communication.
It is an alibi. So it's something that you would be expected to disclose. I defended a scenario like this. We did disclose the alibi. The charge was dropped.
Yep.
Because it was legit. So anyway, go ahead.
I forget where you wanted me to go when I...
Well, what I wanted to talk about was this increasing problem we see of people on motorcycles deciding that because they've seen it on the internet that they're going to try and flee from the police. And motorcycle season is coming up. I note that every year, many people in British Columbia die on motorcycles because almost every collision ends up being in a horrible injuries or death. Horrible injuries very often. We pay for a lot of healthcare for motorcyclists who are in accidents. But these people who have persuaded themselves that they got a chance of getting away, just because you're home free, you're not home free. They can wait outside your house. They know who the owner is of the motorcycle. There's a likelihood that you're the one who's on that motorcycle. They're going to find the bike. They will figure that one out. And
courts often draw the inference that it's the owner that's the one operating.
Yes, and that's exactly it. And that's what happens in this case is there is an inference drawn despite the fact that there is a moment or so of lacking continuity. You and I have had cases where there's lacking continuity and, there was a possibility of generating a reasonable doubt. But these motorcycle failing to stop cases are different. So lack of continuity when there's no expectation that you're not fleeing from the police is a different thing. Somebody drives a vehicle home, goes into the house, there's 50 people in the house and 5 of them are registered owner or permitted to drive that vehicle on the insurance. You can't say who the driver was just because the registered owner or, maybe some glance at somebody that gets some description. But if you're on a motorcycle and you fail to stop for the police, the court is likely to make that inference.
Yep.
And here, I think it was, fairly easy for the judge to come to that conclusion. Nobody's going to question it, despite the fact that it's really like circumstantial in a sense.
I mean, I thought the analysis of the question of reasonable excuse was interesting and worth discussing.
Yep.
So yeah, like I said, he'd modified the vehicle to be really loud, and he argued that this was a reasonable excuse for not stopping for the police officer, which the court did not buy.
Yeah. Well, I didn't believe it because I'm just assuming that the red and blue lights from that police vehicle are flashing ahead of the car. The lights are going faster than
Yeah.
the motorcycle. The lights are traveling at the speed of light.
But there is an issue with the analysis here. So the judge says reasonable excuse is effectively an external factor that truly prevents stopping, not an internal failure to perceive the signal to stop. A reasonable excuse for hypothetical instance could include where stopping immediately would cause an accident due to traffic conditions or where the driver is having a genuine medical emergency, for example, a seizure. But you could also have internal failures that constitute reasonable excuse. One would think about like maybe a mental health issue. Um,
Okay, let me see. You've got a helmet on, and you're driving along. You've got your Bluetooth set. You're listening to it at a low enough level that you can hear, but somehow you bump the thing in your pocket, and it jumps the volume
what if you're deaf?
so high that you can't hear it, or you're deaf. You could be driving around wearing a welding helmet, and it would be it'd suddenly go dark. I don't know. Like
I just think there's
I don't think this is a limited set of
I just the
like examples you could come up with all day long.
the internal failure part gets me. But anyway, the court then says
I think there was a little forgiveness here of the modification to the exhaust ultimately in the end.
in the context of flight from police to conceptually connote, or it's been interpreted to conceptually connote that the excuse must be objectively reasonable and incapable of being based on a condition caused by the accused's own actions or inactions, carelessness or recklessness. It is inappropriate to create a dangerous condition and then use that condition as an excuse for failing to obey the law. And that's where the judge hinges the reasoning.
Which was an interesting one because you create a dangerous situation and then whatever flows from it, you no longer have an excuse.
Yeah.
I think that's a bit of a problem.
Yeah.
But I don't think that, I think every time that there's an excuse pro-offered, we will see that it ends up being a unique scenario. So I don't think this is going to end up being necessarily binding on anybody else, but it'll certainly be influential in the consideration of it.
So the court says, modifying the motorcycle is creating a dangerous situation. If you modify it so it's so loud you can't hear anything around you, that's dumb. Don't do it. And it's your responsibility to be aware. And if you're not aware because you did this, knowing that that's the circumstance it would cause, you don't have a reasonable excuse.
Punishment for being stupid.
Basically, yeah. I guess this guy basically counts as our ridiculous driver of the week too, then.
Could be. There's others. I'm gonna put this.
But what I really have a problem with is paragraph 88 of the judgment, where the court says no evidence has been presented to suggest any emergency, mechanical failure, or other circumstance that would provide a reasonable excuse for this failure. The persuasive onus to establish a reasonable excuse, which rests on the defense, is evidentiary. And in the absence of any such evidence, I find the Crown has proven there is no reasonable excuse. But the court cites the case of Gillespie, which is a BC Court of Appeal decision, was upheld by the Supreme Court of Canada. But that case is no longer good law.
These things happen. The point is that the judge is still correct.
But it seems she's applying a burden on the accused to raise reasonable excuse and prove it on a balance of probabilities, as opposed to raise an error of reality.
Which is all that's required.
And
but
then
he doesn't even get close to that here, I would think.
I guess not, but I just the reference to the Gillespie, when it's been very clear in a number of cases now that the entire decision in Gillespie rested on a provision of the criminal code that's been repealed with the specific intent to eliminate that reasonable excuse as an evidentiary burden for the accused.
It would violate the presumption of innocence if it didn't.
Yes.
All you have to do is, there can be scenarios. You can float scenarios. You don't have to prove it beyond a reasonable doubt. You don't have to prove it on a balance of probabilities. Just, it's a plausible scenario that would make sense, then that is compatible with the WD standard that we apply. And I won't explain WD at this point because most of the people who might be listening probably know what it is.
Yeah. Now, in terms of ridiculous driver of the week, you said there are many.
Sure. There was somebody I sent you on TikTok who tried to drive around a barricade. An Amtrak train was coming and had the front of their car torn off. That was a very ridiculous driver of the week. This was in the U.S. It shocks me that, like, I think of how much my parents talked about the dangers of railway crossings. It just shocks me that I'd ever seen. But I did see that in Edmonton back when I was about 17, somebody driving around a barricade while an LRT train was coming.
I'm always terrified about like driving over train tracks and like what if the vehicle gets stuck on the train tracks or, the other day I was in Port Coquitlam and you know how when you're going to the Port Coquitlam courthouse, you have to drive over those train tracks? Somebody stopped on the tracks waiting at the red light.
Yeah.
And I was like, what is wrong with you? This is an active railway line.
I was dropped off my child and I was coming down Renfrew, I guess it is. Same thing. I saw it again. Active railway line. Also, dash cam video shows Vince Mahon's 100-mile-an-hour car accident. He is a McMahon. Sorry, I picked up my glasses.
So I figured you were talking about.
And it looks like he's driving his Bentley and rear ends a Mercedes. That was a dramatic one, pretty bad.
So I'm sure he has really good insurance.
And then there was the sinkhole yesterday, which aren't really ridiculous drivers, but did you see the
Yeah, I
videos
did
of
see
that?
the video of the sinkhole.
The
What are the
Dodge
odds?
truck, 2 vehicles dropped down exactly in the sinkhole. It's such good video they had of it. Yeah, so there was lots of ridiculous incidents of the week, that's for sure.
Good.
And then there was this one on CTV News, truck hanging from Winnipeg overpass following crash.
A crash with an overpass that wasn't in BC?
Look at that. Hanging. Oh my gosh, look. Hanging from the overpass.
No, an overpass crash can only happen in British Columbia. That is
terrifying. Yeah, that's true. It's really a BC thing.
Yeah.
There was the one that was in your Weird and Wacky Wednesdays this week of the fellow who was fleeing from the police.
Mm-hmm.
Hid in a trash can. The police lost him, didn't know where he was. The police stopped, they're parked, they're trying to figure out where could this guy have gone. He got into a trash can and it was just as the trash was coming to pick it up. Guy rolls the trash can up to the garbage. The fellow operating the sanitation engineer rolls the trash can up to the back of the garbage truck, opens the lid, and this guy jumps out and runs. And of course the police are sitting there and it's all on dash cam.
That's great.
Police are sitting there, and
That's hilarious.
and this guy comes popping out, and then there he is.
It reminds me of that joke. You know that joke where like there's 3 people running from the police and they're on a farm and they all jump in the barn and one jumps into a pile of puppies and the police come and kick the puppies and they go woof. And then the second one, it's a pile of kittens and they go meow. And then the third one, it's a bale of straw and they kick the bale of straw and she goes, straw.
Ha ha ha. Then there's other one I sent you a while back. BCN driver clocked at 200 kilometers an hour, said she wanted to test her new Mustang.
I mean, there's a reasonable excuse if I ever heard one.
Yeah, but I don't believe it at all because the photograph is not of a Mustang. It's of a Chev.
And it's probably one of those fake news things.
Yeah, that's the thing. And look at the police officer there.
There's also no N on the car.
Yeah.
And is that even a BC license plate?
I don't know.
It looks kind of green.
I don't know. I sent it to you. Canada 2247. She tried testing the engine, it says. It says 39-year-old Penticton driver with a Class 7 N. Well, could have happened, but...
I guess maybe she wasn't displaying her N.
Could be. That could be too, but also wasn't a Mustang. So.
Well, lots of ridiculous drivers this week.
Yes, and it's spring almost in Vancouver. The rest of the country, it may not feel like it, but we're going to have a sunny weekend. And be careful out there because, as I say, it's the beginning of distracted driving and seatbelt enforcement month.
Well, if you get a distracted driving ticket or any other driving-related charge, you can give us a call at 604-685-8889 or find us online at vancouvercriminallaw.com and tune in next week for another exciting episode of Driving Law.